बेटा अलग से इनवाइट करना है, व्हाट्सएप करूँ सबको, पर्सनल मैसेज तो नहीं करना है, शिफ्ट हो जाओगे। शिवेत्री गूगल मीट है।
इनको चेक करना पड़ेगा वॉइस आ रही है।
आंसर जब मैम बोल लेंगी इसके बाद हम इसको एक बार करके देख लें, एक बार आप देखना।
टेस्टिंग करना
आवाज आ रही है।
क्या हुआ? चल रही हो चल तू निकाल तुम भाभी लोग हटा दे तो कोई चलता है डबल
लाइट इमेज
पर बोली चार बजे बाद में लोग
बर्थडे
तो काट लिया क्यों
सर हो गया सेकंड।
सर सर फाइव क्या
बस हाँ लाइट देखनी है। हाँ ये तो
हाँ एक्चुअली बेटा मालूम हुआ फिर हमारा वहाँ से पुलिस वहाँ से आए वो अब आए वो अब वही तो करते हैं क्या कर रहा आई
करना है ना। जब ये हट जाए मनीषा मैम तो इसको थोड़ा सा सेट करना है, हो गया मेरे तरफ।
ठीक हो गया तो देखिए सुनाओ हम लोग इनका इनका वॉइस जो इससे इससे वाला ये दो खाली हाँ ये खाली की बोला तेरे को ये ब्लैक बस
देव पहले का इसके हिसाब से देखना इसने मुझे पहले ये करा है चाहे
कर देगा ब्लैक
माइक की बंद हो
वही बस वहां से कर देंगे
देव देव अपने मैम ने बोला हौसला नहीं है।
ये तो आएगा ही यार नहीं वहां से भी बोल उस वाले माइक से उस वाले माइक से भी बोल सकता है अच्छा वो ये तो उसके लिए कोई मीटिंग वगैरह करता है उसके लिए लेकिन लेकिन अगर इसको कमेंट कर दिया सकता ही है हमें तो कितना ही बोलना है ये नहीं पर एक बार साउंड टेस्ट करना यार यहाँ से बहुत क्या मैम बोलेंगे उनके फोन में लॉन्च है ठीक है
ये वाला से लगता है
या तो ऑनलाइन हाँ
ये वाला क्या
मैम सीधी आवाज आ रही है
हेलो हमारे ऑडियो चाहिए तो हमारे
Yes,
बात
yes. Good morning.
ये सब लोग चुप हो जाओ।
Good morning, everyone. Honorable dignitaries, esteemed faculty members, distinguished guests, dear students, and all those joining us virtually. A very warm welcome to all of you. I am Manisha Milkan, Faculty School of Law, Nachiketa University, and it is an absolute privilege to commence this historic lecture series with you, sir. A platform dedicated to critically examining the 75-year journey of the Indian Constitution. To everyone present here in this hall and to those joining us virtually, welcome to a discussion that is as relevant as it is fascinating. For 75 years, the Indian Constitution has been more than just a legal document. It has been a living, breathing testament to democracy, shaping governance, justice, and individual rights. But today, as we stand at the crossroads of history, we must ask, have constitutional amendments truly strengthened democracy, or have they diluted its essence? Is judicial activism a protector of justice, or has it encroached upon governance? Has economic justice been realized by all, or does it remain a privilege? And most importantly, what must we do to ensure that our legal system remains truly inclusive, effective, and just? These are not just questions, they are the realities of our time. And this is precisely what Vidisatva is about. A bold, unfiltered, and intellectually rigorous space where legal scholars, jurists, academicians, and practitioners critically engage with these pressing concerns. Ladies and gentlemen, it is my absolute honor and privilege to introduce to you Senior Advocate Nachiketa Joshi, a towering figure in India's legal landscape whose journey in law is as inspiring as it is formidable. Mr. Joshi completed his 5-year integrated law degree from the prestigious ILS Law College, Pune, between 1998 and 2003. Immediately after, he enrolled in 2003 and began chamber practice alongside his father, Sri Sudhakar Joshi, in the High Court of Gujarat and Ahmedabad. After a roaring 12 years of rigorous and result-driven practice at the High Court, he made a pivotal shift in 2008 to the Supreme Court of India, where he has been practicing independently from day one. In 2010, he cleared the Advocate on Record examination, a milestone for every Supreme Court lawyer, and since then, his litigation practice has spanned a wide range of matters, including civil, criminal, labor, and service law. He was appointed Additional Advocate General for the state of Madhya Pradesh in the Supreme Court in 2023, and most recently, on 14 August 2024, he was designated as a senior advocate by the Honorable Supreme Court of India, a recognition reserved for only the most distinguished and meritorious advocates. With over 100 quoted judgments to his name and several published articles, Mr. Joshi stands at the confluence of scholarly insight and courtroom excellence. Notably, he has represented the state of Madhya Pradesh in landmark environmental and constitutional cases, including legal battles concerning the disposal of toxic waste of the 1984 Bhopal gas tragedy from the Union Carbide plant. His expertise in navigating constitutional intricacies and governance challenges makes him a perfect speaker for today's session. We are truly grateful to him for joining us today. And I request everyone to listen with undivided attention. To those attending virtually, please share your questions in the chat box. To our students here in the hall, note down your queries. We will earn your best post lecture. With that, let us begin. It is now my absolute honor to invite Senior Advocate Nachiketa Joshi to take this session forward. Over to you, sir.
Thank you so much. Am I audible?
Yes, sir.
Thank you. Honorable faculty members, respected scholars, students sitting over there on the dais, off the dais, thank you so much for this privilege. It's an honor to be delivering this lecture online. I would have wished I could have come physically there because interactions, I think, make more effective when you are physically there with a person. But due to the distance and paucity of time, I'm here online. So kindly excuse me on that. It is truly a privilege to address this esteemed gathering today on the topic which lies at the heart of the democracy: economic justice and the constitution, law, policy, and governance. The Constitution of India, a document of vision and progress, is not just a legal manuscript, but a social contract that aspires to build an equitable society. Economic justice is a fundamental pillar of the vision, ensuring the resources, opportunities, and privileges that are distributed fairly among all citizens. Before we delve into the complexities of the constitutional law, let me clarify that the legal discussion, much like the courtroom argument, must be engaging. I promise not to make this a 2 hour long speech and whereby there would be a lot of boredom. I would only be highlighting the important aspects and the judgments which have paved the way for the economic justice in this country. The word justice is derived from a French word, justice, which means uprightness, equity, vindication of right, and administration of law. The concept of justice is as old as civilization and society. There can't be existence of lawful society without the presence of justice. One of the most important pillars of any nation is justice. A lawful society can't exist without the presence of justice. It is one of the most important pillars behind the growth of any nation. Justice means justice in the correct application of a law as opposed to arbitrariness. By the correct application of law, we mean to say the proper implementation of law. Justice can't be attained in the society only by correct interpretation and implementation. What is economic justice? Is it merely the redistribution of wealth, or does it extend beyond to that to encompass opportunities, social mobility, and empowerment? Dr. B.R. Ambedkar, the principal architect of our constitution, envisioned economic justice as an inseparable pillar of our democracy. It is not merely about removing economic inequalities, but about creating a system that fosters economic participation, ensuring that no individual is deprived of the basic necessities of life due to a systematic barriers. The preamble of our constitution sets the stage by promising justice, which is social, economic, and political. But the real challenge lies in the implementation of this promise. The journey from a mere textual guarantee to meaningful realization is an ongoing one, influenced by various constitutional amendments, judicial pronouncements, and policy frameworks. The phrase social justice appears in the political and humanitarian literature of the 18th century of Europe as a result of the necessity of removing social status indignities which have become part of the feudal order. With the development of an industrial society, education and economic betterment, the indigenities based upon the classes have largely disappeared in the European countries. In the context of India, it is suggested that it will lead to a greater clarity of thinking, perhaps better implementation of the ideals of social justice if the phrase social justice is kept confined in the literature of law to certain programs relating to removal of class distinction and indignities that are part and parcel of the Indian society today. The present day rolled up reference presents a proper perspective being given to social justice values in the strict sense, because when they get mixed up with the economic values, certain inherent vested interest approaches inhibit clear thinking and make an effective handling of social injustices which are impossible. The preamble of our constitution, the guiding star of our legal framework, explicitly mentions justice, which is social, economic, and political. Economic justice, thus, is not an afterthought, but a foundational promise. The framers of the constitution were conscious of the economic inequalities that plagued India during that society's period. Dr. B.R. Ambedkar, the chief architect, emphasized that mere political democracy is insufficient without economic democracy. The Indian Constitution is a living document that adapts to changing social economic conditions. Economic justice finds its roots primarily in the directive principles of the state policy, which is the part 4 of the Constitution from Articles 38 onwards, which guide the state to promote the welfare of the people, secure equal pay for equal work, and prevent concentration of wealth. Article 38 directs the state to promote the welfare of the people by ensuring social, economic, and political justice. It urges the government to reduce inequalities, not just in income, but also in opportunities, status, and access to resources. The principle has inspired landmark policies like the Minimum Wages Act, the Financial Inclusions, and Social Security schemes. Article 39 lays down key economic directives. It ensures that citizens have the right to adequate livelihood, wealth, and resources that are distributed for the common good, equal pay for equal work, which is guaranteed for men and women equally. Workers and children are protected from exploitation. These provisions have shaped laws like Manrega, the Equal Remuneration Act, the labor welfare schemes. However, challenges remain. Income inequality, job insecurity, and gender wage gaps still persist. The road ahead is clear. We need strong labor laws, better wealth distribution, and skill development programs to truly uphold these principles. The spirit of Article 38 and 39 is not just legal, it is a promise to every Indian that justice and opportunity will not be limited to a privileged few. All these types of justices are closely related to each other. One can't be achieved unless and until the other are present. Social justice can be achieved only when economic and political justice is present. Indian Constitution under Part 3 of the Constitution enforces all three types of justices by making provisions relating to equality under Article 14 and 15. In 2019, the 103rd constitutional amendment was brought about to ensure economic justice for everyone. The jurisprudence behind this amendment was implementation of economic justice. Our fundamental rights under Part 3 protect individuals from economic exploitation and discrimination. Fundamental rights enshrined in Part 3 of the Constitution serve as the backbone of economic justice by protecting individuals and from exploitation, discrimination, and economic inequalities. These rights ensure that every citizen has access to fair opportunities, decent working conditions, and protection from oppressive economic structures. Article 19(1)(g) gives citizens the right to practice any profession or trade, allowing economic freedom and entrepreneurship. However, the state can impose reasonable restrictions in the interest of public welfare, ensuring that business operate fairly and ethically. Article 21 similarly ensures that the right to life and dignity, which includes the access to basic economic necessities such as food, shelter, and health, are provided. This has been upheld by courts in the case of Olga Tellis, where the right to livelihood was recognized as an integral part of Article 21. Article 23 and 24 prohibit forced labor and child labor, safeguarding vulnerable workers from exploitation. Laws like Minimum Wages Act, Bonded Labor System Act, Child Labor Act stem from these provisions. Article 15 and 16 prohibit discrimination in employment and education. While these rights lay the foundation for economic justice, challenges such as income disparity, working discrimination, and unfair labor practice still persist. Strengthening enforcement mechanisms, ensuring access to legal remedies, and promoting economic inclusion remain key to realizing the true spirit of these constitutional guarantees. The basic structure doctrine, as established by the Supreme Court, ensures that economic justice remains a non negotiable principle of our Constitution. It prevents any government, no matter how powerful, from altering the fundamental ideals that uphold democracy, equality, and justice. The doctrine was first laid down in the landmark judgment of the Keshavananda Bharati case, where the Supreme Court ruled that while Parliament has the power to amend the Constitution, it cannot change its basic structure. Among the core elements protected under the doctrine are social and economic justice, ensuring that any policy or law cannot undermine these economic justices as part of the Constitution's directive principles of state policies. The judiciary has reaffirmed its significance through various judgments. Just to mention a few, in Indira Sawhney versus Union of India, the court upheld the reservations for backward classes, reinforcing the principle of economic inclusivity. In Minreva Mills versus Union of India, the Supreme Court ruled that harmony between fundamental rights and the directive principles is essential, safeguarding policies aimed at reducing wealth concentration. In state of Tamil Nadu versus Abu Karur Bai, the court supported land reforms, ensuring that wealth does not remain concentrated in the hands of few. The doctrine serves as a constitutional safeguard, ensuring that no amendment or executive action can override the commitment of reducing inequalities, providing fair opportunities, and upholding socio-economic justice. It reinforces that economic justice is not just a policy choice, it is a constitutional obligation that governments must uphold at all times. Over the decades, various amendments have played a crucial role in ensuring economic justice. The first amendment of 1951 was bringing about for balancing property rights and socio-economic reforms. The 25th Amendment of 1971 was in relation to the rise of socialism and economic justice. The 42nd Amendment was again a social commitment whereby socialist word was entered and brought about in the preamble. The 73rd and the 74th Amendment were in relation to the decentralization and economic developments. Similarly, the latest 101 Amendment of 2016 was about the GST regime, which was a landmark reform, the introduction of the goods and service tax, which streamlined indirect taxation and enhanced economic efficiency. It eliminated tax barriers across states, creating a unified market while improving revenue collection. The Supreme Court of India has been instrumental in shaping the concept of economic justice through its judgments. By interpreting constitutional provisions dynamically, the judiciary has reinforced economic justice as a fundamental principle in governance and policy making. Some of these landmark judgments include, as I indicated earlier, the Keshavananda Bharati judgment, the Maneka Gandhi judgment, and the Olga Tellis judgments. In Keshavananda, this case was a turning point of Indian constitution. While the constitution, the judgment laid down the foundation for economic justice as an inseparable element of governance. The Supreme Court ruled that the basic structure doctrine limits Parliament's amending power, ensuring that fundamental principles, including social and economic justice, cannot be diluted or destroyed. This doctrine safeguards progressive legislation aimed at reducing inequality and promoting economic fairness, ensuring that the directive principles remain enforceable through legislative and executive action. Similarly, in the case of Maneka Gandhi, the Supreme Court redefined the scope of Article 21, expanding it beyond mere existence to encompass the right to life with dignity. The interpretation had a far-reaching impact on policies relating to Minimum Wages Act, labor laws, housing for the poor, and employment schemes, ensuring that economic justice becomes a core aspect of human dignity. In the case of Olga Tellis, which is often referred to as the pavement dwellers case, the judgment reinforced that the right to life under Article 21 includes the right to livelihood. The case arose when the Bombay Municipal Corporation decided to evict thousands of slum dwellers and pavement residents without alternative rehabilitation. The Supreme Court ruled that forced eviction without due process violates the fundamental right to livelihood. It recognized that economic justice requires policies to ensure employment opportunities, shelter, and protection against arbitrary displacement, particularly for vulnerable groups. This decision influenced urban planning laws, slum rehabilitation policies, and housing rights in India. The Indira Sahni judgment on reservation was a landmark judgment which upheld reservations for the socially and economically disadvantaged under Article 15.4 and 16.4, reinforcing affirmative action as a means to achieve economic justice. The Supreme Court ruled that economic backwardness, in combination with social disadvantages, justifies reservation in education and public employment. The judgment also introduced the 50% ceiling on reservations but allowed flexibility in exceptional circumstances. Judicial interpretations have played a decisive role in transforming constitutional provisions into enforceable economic rights. Though progressive judgments, the Supreme Court has ensured that economic justice remains a dynamic, evolving, and enforceable principle guiding India's legal and policy framework towards a fairer and more equitable society. On the aspects of governance and policy, the economic justice is not merely a constitutional aspiration, but it's a practical necessity that requires strong policy implementation. The government's role in ensuring economic justice extends beyond constitutional provisions, shaping policies that direct impact the lives of millions. Some of the most significant initiatives include the Mahatma Gandhi National Rural Employment Guarantee Act, which was brought about in 2005 as one of the world's largest employment program, guaranteeing 100 days of wage employment per year to rural households. It not only provides financial security but also empowers rural workers, reduces poverty, and enhances rural infrastructure. The scheme is crucial in ensuring economic justice by offering livelihood security and protecting the vulnerable population from economic distress. The public distribution system of ensuring food security is another policy decision which the governments have taken over the time. The PDS, as it is known, is a lifeline for millions, ensuring subsidized access to essential food grains like rice, wheat, and sugar for the poor. Strengthened by the National Food Security Act of 2013, it guarantees food entitlements to nearly 67% of the Indian population, promoting economic justice through nutritional security. By reducing hunger and malnutrition, the public distribution system plays a pivotal role in bridging economic inequalities. The Pradhan Mantri Jan Dhan Yojana is on the financial inclusion for all, which was launched in 2014. The scheme is the world's largest financial inclusive initiative aiming to provide banking access, insurance, and credit facilities to the poor. Over 50 crore bank accounts have been opened, enabling direct benefit transfers and reducing leakages in welfare schemes. The scheme has empowered marginalized communities by integrating them into the formal economy, ensuring financial justice and economic empowerment. The Reservation for Economically Weaker Section (EWS) through the 103rd Constitutional Amendment of 2019 introduced 10% reservation in education and government jobs for individuals from economically weaker section of the general category. It marked a historic shift by recognizing economic deprivation as a criteria for affirmative action, previously focused only on a caste-based disadvantage. The EWS reservation is a step towards ensuring economic upliftment, reducing wealth disparities, and promoting inclusive growth. These policies therefore reflect the government's commitment to economic justice beyond constitutional mandates. By addressing employment, food security, financial inclusion, and equitable opportunities, they strengthen the foundation of a fair and just society. However, continuous monitoring, efficient implementation, and policy innovation remain key to achieving true economic justice for all. Despite strong constitutional provisions and policy initiatives, several barriers hinder the realization of true economic justice in India. These challenges create structural inequalities, preventing equitable distribution of resources and opportunities. I- Income inequality has become a very serious concern. A small percentage of the population controls a disproportionate share of wealth while millions struggle for basic needs. Economic growth has not translated equally across all sections of the society, leaving marginalized communities still far behind. Therefore, the bridging of this gap between the persons who still don't have the amenities and those who have has to be the basic concern of the country as such and people of this country. Unemployment and underemployment still remain an issue in India. The lack of adequate job opportunities are still pressing and issues, especially for the youth. Though the policies have brought about various incentives, there are still so many youth in India who still don't have those basic job opportunities which would otherwise be available. Underemployment, where individuals work in jobs below their skill levels, are limits upward their mobility. The rapid evolution of technology and automation is rendering many traditional jobs obsolete, worsening the employment crisis. The judicial backlog in courts is also a serious concern, and which is delaying the economic justice. The slow judicial process in India often delays resolution in cases relating to wages, property rights, and labor disputes. Prolonged litigation discourages workers and businesses from seeking legal remedies. Ensuring speedy justice in economic matters is crucial to maintain trust in the entire system. Corruption and bureaucratic hurdles are the blockages for the welfare implementation. Corruption in public offices and welfare schemes often leads to misallocation of funds. Bureaucratic red tape makes it difficult for marginalized groups to access government benefits. Ensuring transparent governance and efficient service delivery is essential for economic justice to be meaningful. The digital divide is also a concern on the exclusion from technological disadvantages. Digital access is essential for economic participation, but rural and unprivileged population lack connectivity, digital literacy, and infrastructure. The shift to digital banking, e-governance, and online education risks the excluding those who lack access to smartphones, the internet, or the technology skill. Bridging this divide is necessary to ensure equal access to opportunities in the digital economy. Therefore, achieving economic justice requires not just policies but also systematic reforms to tackle these challenges. Bridging economic gaps, strengthening job markets, improving judicial efficiency, ensuring transparency, and promoting digital inclusion are crucial steps towards building a truly just and equitable society. Now, what is the way forward in all this? To transform economic justice from an ideal into a reality, India must adopt a multi-pronged approach that strengthens laws, improves governance, enhances skills, fosters partnerships, and expands digital accessibility. Strengthening labor laws to ensure fair wages, safe working conditions, and job security is the concern of the nation. Strengthening anti discrimination laws to prevent economic exclusion based on caste, gender, or socio-economic backwardness is also a grave concern. Strengthening consumer protection mechanism to safeguard individuals from financial exploitation should be the priority. Improving the governance through transparency, accountability, and efficiency is the hallmark for economic justice. Reducing bureaucratic delays, corruption in welfare programs, ensuring better policy implementation so that benefits reach the intended beneficiaries, Strengthening social audits and grievance redressal mechanism to hold authorities accountable are key in this regard. The focus on educational and skill development has to be brought about. Investing in vocational training programs to align skills with market demands, ensuring quality education for marginalized communities to break the cycle of poverty, and encouraging entrepreneurship through financial assistance and mentorship programs are key in the economic justice development. Promoting public private partnerships and the corporate involvement in social welfare schemes are also important. Leveraging corporate social responsibility, the CSR initiatives to fund employment programs, education, and rural development have to some extent brought about to cover this gap. Encourage private sectoral investment in affordable housing, healthcare, and financial inclusion is important. Fostering collaboration between government, industry, and academia for skill enhancement programs will be the next path breaking decision if the government implements. Expanding digital inclusions is also an important aspect. To improve internet connectivity in rural areas to bridge the digital divide is important. Introducing affordable digital literacy programs to ensure marginalized communities will go a long way. Promoting financial inclusion through digital banking to ensure easy access to economic resources will bring about to fill the gap as it is there between the economic sectors of the rural India and the developed India. Achieving economic justice requires a sustained effort from all stakeholders, the government, the judiciary, corporate sector, and civil society all together. Strengthening legal protections, improving governance, investing in education, fostering public private partnership, and ensuring digital accessibility are essential steps towards an equitable and just economic system. To conclude, economic justice is not just a constitutional promise, it is a shared responsibility. Lawmakers, the judiciary, policymakers, and all the citizens have a equal role to play in creating a fair and inclusive economic system. Let me end this with a touch of humor. If wealth were distributed as easily as WhatsApp messages, we would all be billionaires by now. But unfortunately, economic justice requires more than just forwarding slogans. It demands real action, commitment, and systematic change. As we move forward, let us remember a truly just society is not just one where the richer get richer, but one where the poor have a fair chance to rise. Thank you so much.
Thank you, sir. Now, there are some questions that the students want to ask.
Yes.
If you know me. Okay, Simran, good morning, sir.
Morning.
So my question from you is that you mentioned that economic justice is not just a choice, but an obligation. You said some obligations lies in economic growth rather than the economic justice, and that this nature eventually leads to people total society.
Yes. So, what is your question?
So my question is it economic justice not really an application of economic growth economic?
Correct. Economic justice, in a sense, is a subset of economic growth, as you are saying. Economic growth and economic justice are both, they both go hand in hand. You're right. Economic justice has within itself, or it goes along with the economic growth. Because if you have economic growth, as you are indicating, where the poor person are getting richer, they have the opportunities. That, in a way, is bringing about an economic justice. So I think both are in together, going hand in hand. You're right. You can call it economic justice, you can call it economic growth, both ways.
So actually, I think like nations like USA, they focus on more economic but justice. Like we focus on reservations and other stuff, for fairness and equitable. We have to really grow. So I think that we should more focus on growth than the equitable.
That's a valid suggestion. I take that.
Thank you, sir.
Thank you.
Good morning, sir.
Yes, good evening.
So my question from you is, sir, equal pay for equal work is a fundamental principle of economic justice. You agree?
Yes.
Still, it is more a DPSP, not a fundamental right. So why?
DPSP is not a fundamental right.
Yes.
Directive principles have not achieved the status of fundamental rights. They are still, at a stage where, therefore, the government is making efforts. What is happening is, over the time, we have realized that though it has been categorized as the directive principles, and as a fundamental right, you cannot assert that I would be entitled to this. The government is trying to make efforts to ensure, by bringing about schemes, by bringing about policies, whereby the directive principles are made more effective. But yes, there is a time when these directive principles will have to, somewhere come into the league of fundamental rights, because what have we achieved under the fundamental rights has already been there. There have been so many streamlines of equality and other things which are there in fundamental rights, but now we need to concentrate on the directive principles, and we need that amendment somewhere. This is my personal opinion, that the directive principles should be made enforceable. Only then this economic justice can be brought about. Thank you.
One, sir.
Good much.
Sir, my question would be that as there are developments and we are moving towards a digital world. So, how courts they use the PILs to address issues like the denial of pensions, rations, due to digital glitches and or biometric mismatches in the messages data. That should also it's a wrong policy.
Correct. That's a valid question. Uh, Digital PILs have played a very important role. There have been times in the 1980s, 1990s, there were a lot of PILs which were happening. And PILs were happening in a very structured manner. They were very constructive PILs which would bring about all these problems. In the last 10 years, in the last 1 decade, I feel the kind of PILs which should come up with these social economic issues are not coming up. Therefore, we need students like you who should be concerned and should take up these issues. As you indicated, I was handling one PIL. That PIL was in relation to the ration which is being distributed, and the entire PDS scheme which goes in, and the distribution not happening fairly. So in that PIL, we brought about the disparities that was coming from the state of Rajasthan, and we brought about the disparities how the scheme, though there in place, it was not actually reaching the people for whom it was meant to be, to reach, and there were bureaucrat problems, there were other issues, there was corruption, and then we pointed out with suggestions as to what can be done to make this foolproof. So yes, these issues where the ration being reaching the people through PILs, issues can be raised. Issues like pensions also, salaries also. So the government has been working out. Now the pension which was previously being paid to a person only when he goes to the office of that employer has now made it very suitable in the sense that that pension comes automatically to your account. Therefore, that connection of the banks with your bank accounts, with your employer, has brought about a swift change. But still, there are issues, there are problems. So, therefore, with clear problems, people should research on this. I urge that universities, colleges like you should, you should have teams who can work upon these social problems and have them worked out. and then approach someone through whom you can file these PILs and take up this issue. It's a very valid point that you've raised. Thank you.
One more question.
Yes, yes.
Sir, do you think that the constitution now it needs to evolve to protect the digital gig workers like the food delivery agents or the rideshare drivers under the economic rights?
Yes, the constitution has to evolve. Constitution has always been considered as an evolving document. But with that, what we need legislations. We need legislations which will bring about a curb or a manner in which all this is regulated. There is no regulation on all these. Therefore, a regulatory mechanism which can bring about, the process in which the entire thing happens is very important. I think OTT is also a very serious issue before this country, and therefore the government has to bring about some mechanism, some legal framework whereby you control all this, because these days we see there's on social media and otherwise on the internet you have so much of material on the OTT as well, which is uncontrolled. So these are issues on which the government must bring about, and there could be PILs on this. The courts can be asked to work out on them, that the government should be directed that they may bring about a policy decision, bring about the regulations, bring about a framework under which all this will work. So you're right, that has to be controlled and worked upon.
Sir.
Thank you. Only girls, all girls are coming, no boys are coming to ask me a question. Huh?
Since judgment, the Supreme Court has emphasized constitutional morality and economic governance. How should this principle guide economic policy making in India?
The first part, can you just repeat? I couldn't follow that. What are you
The
saying?
Supreme Court has emphasized constitutional morality.
Sorry? The Supreme Court? Constitutional morality. Yes. What is your question on that?
So, this statement has emphasized an economic governance. How should this principle help to policy making in India?
Constitutional morality is a completely different concept, which has been, you would have seen the Sabrimala judgment. The Sabrimala judgment, where Justice Indu Malhotra brought about the constitutional morality concept. Now, that's a social issue on which constitutional morality will have its own role, and therefore, what would be constitutional morality will have its impact on the social justice system, and in turn will have it on the economic justice. But I don't think there is a direct connection between the constitutional morality with economic justice. However, the social justice fabric which is there in India, their constitutional morality is an evolving concept, and I'm sure in the longer time this will play a very important issue where India decides as to what is constitutional morality and how do we govern by that. Thank you. Yeah.
So my question is that shouldn't the pay should be based on the basis of the work performed, not on the basis of the gender? Like
Sorry, 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 can you repeat?
my question is, shouldn't the pay which is being provided
Pay?
pay like wages and all
Wages.
should be on the basis of the quality of the work performed, or like the work performed, not on the basis of gender? Like why we always
Not on the basis of
not on the basis of gender?
gender.
Like why we always issue with gender? If the man can perform better labor work, it should be the pay should be free. No, it should whatever don't take go better work maintenance or things and management things. Neither the pay should be more. So my question is that why we are always confusing this issue after so many years of independence with the gender not on the work performed.
Uh, I have my own reservations on the issue that you have raised. In the sense, I don't think there is any discrimination per se on gender basis. I don't think women are paid less. If you go on the corporate side, if you look at any other job, women are equally paid, and men are not paid less. Neither are men paid more. So at least what we have been seeing is it's always the skills of that person which matter, and the skills decide the wages of that person. But yes, our minimum wages act has to improve. The basic pay, which is payable in the US or in the European countries, is much higher than what we are paid here. The amount, the number of hours where a person puts in into his job, that is also really very harsh in India, in the sense where we have people who are working for 10 hours, 12 hours, and not getting that much. So minimum wages upliftment, enhanced wages, that is a concern which this country must be looking at. It is for government to bring about a legislation whereby it can cap about it. And it is also a concern for the employers in general will have to ensure that the wages are at a rate which are respectable for that person to live in any city. Thank you.
I'm sorry, there is one more question.
Yeah. Please.
Good morning, sir. Good morning, sir. Sir, I have a question that I want to introduce to you.
Can you come closer to the mic? I'm sorry. Can you speak closer to the mic?
Good morning, sir. My question is about how can we ensure that the justice system pays rent towards the plate condition of the socially deprived community? Deprived community.
Sorry, you will have to repeat. I'm not able to.
Okay. I was like, how can we ensure that the justice system pays towards the right conditions of the society, deprived communities?
Justice system plays
Towards the condition of the society, deprived communities.
in private communities.
Yes.
In private
Deprived community.
Deprived communities.
in deprived communities. Deprived communities. Yeah. So justice system, therefore, in India has, as I indicated, some of the judgments. The justice system has been working for the deprived and the marginalized society. There have been judgments where the Supreme Court or various high courts have been very concerned as to how to bring about this, the labor law issues, the wages issues, the PDS schemes where they have to be distributed between these people. The COVID time also saw a very serious glaring issue where laborers were all going back. So courts did interfere in these issues and have been looking into it. But as I indicated previously, we need more judges who can be more concerned on the issues of social problems. These days we are getting swayed away with other developmental issues and political issues, and the courts therefore have to ensure somewhere that how do you bring about the deprived class at par with the other classes. And this will happen only with time. It will happen with persons like you taking up judiciary, and persons like you going into the judiciary and trying to make a difference to this entire system. Thank you.
So much, sir.
So, this has been an enlightening and thought-provoking session, and the way you have addressed the questions of the students, it was really nice. Ladies and gentlemen, Senior Advocate Nachiketa Joshi has taken us through an insightful exploration of economic justice and the Constitution, law, policy, and government. His analysis of the constitutional provisions, judicial interventions, and the evolving roles in governance in economic justice have given us much to think about. Sir, on behalf of the School of Law at Nachiketa University and everyone present here, I extend my deepest gratitude to you. Your insights and perspectives have provided us with a more profound understanding of how our work is in shaping economic. It has been an honor to have you here with us today. Thank you, sir.
It was really a privilege. Thank you so much for this opportunity. Thank you so much to all the members there of the faculty as well as Manisha for taking this initiative. Thank you so much.
Thank you, sir. With that, I will formally conclude this session. Thank you once again, Mr. Joshi. And thank you all for being a part of this interesting discourse. See you all around today.
Thank you.
So,